All right, guys, let's get started. So welcome everybody to today's open forum. We have a very special guest and a very special topic today. A lot of you guys have been asking about. Sorry, I have to admit people when they come in. And so we have a very special guest, a very exciting topic. There's been much ado about this topic and a lot of misunderstanding and a lot of questions, a lot of hand wringing. We have with us today a very special guest, Catherine Smith. Catherine does a lot of legal work for us at FRI. She's a wonderful real estate attorney. She does other business litigation as well, banking law, real estate transactions, homeowner association law, all the stuff that you guys need help with a lot. Catherine, you are muted right now, but I wanted to introduce you, let you introduce yourself to everyone. She's a wonderful asset to us at FRI, and she's here to explain this to you from the legal perspective. Thank you very much for coming in today, Catherine.
No, thank you for having me. As Ryan mentioned, my name is Catherine Smith. I am an attorney in the state of Florida. I have been practicing in the state of Florida since 1996. Sorry, I've been a practicing attorney since 1992. I'm also barred in the state of California. So I've been practicing since 92, since 96 in the state of Florida. I am a native Floridian. I just went out to California for a few years to do my schooling. So that's why I was barred first in the state of California. But I primarily practice in general civil litigation with an emphasis on real estate law and also just general civil litigation. Don't do personal injury, don't do family law. So any other types of civil litigation disputes, but a lot of real estate litigation. I've been working with FRI and Carissa for, I don't know, probably 5 years or so now. So I do a lot of work, on kind of both sides of the house, with FRI and all of the needs that they have. And Ryan and Carissa asked me to come and talk to you today about this new law that was passed just within the past month that's going to go into effect on July 1st, maybe. And we'll get to the maybes, as I further discuss it. So I don't know if you want me to jump right in or if there's some other business that you're going to do first, or if this is just the whole topic for today.
You are the main topic today.
Okay.
It's all about you.
All right. So as I think all of you probably know, Senate Bill 264 was passed by the Florida legislature and then signed into law by Governor DeSantis on May 8th of 2023. This new law, as I think all of you probably are aware, presents several new restrictions on persons or entities from certain foreign countries of concern, which are defined as the People's Republic of China, the Russian Federation, the Islamic Republic of Iran, the Democratic People's Republic of Korea, the Republic of Cuba, the Venezuelan regime, and the Syrian Arab Republic. The most concerning one, of course, being the People's Republic of China. The restrictions are most severe relating to the People's Republic of China. This law is set to go into effect as of July 1st, 2023. And the reason that I said maybe is because as of Monday of this week, there has already been a lawsuit filed challenging the constitutionality of this law. So I'll address that lawsuit a little bit later as we discuss things this morning. But I'll first talk about, what the provisions of the law are and the potential impacts of this litigation that have already been filed. So specifically, the new law prohibits governmental entities in Florida from contracting with these foreign countries of concern, the ones that I've delineated. It prohibits governmental entities in Florida from entering into any contract or agreement granting economic incentives to a foreign country of concern. But most importantly for our discussion today, it prohibits the ownership of agricultural land and certain asset classes, such as real property near a military installation or a critical infrastructure, and I'll explain what those things mean, by foreign principals of any of these governments or foreign countries of concern. And it largely restricts most ownership by foreign principals from the People's Republic of China. So there's there's several different provisions and they affect ownership in different ways. So there's only minimal carve-outs or exceptions to the new law. And so it's this law, if it stays effective, will be widely felt by Florida's real estate industry. There's, as I think all of you know, there are military installations and these critical infrastructure facilities, again, which I'll describe what that means, all over the state of Florida. So there is going to be potentially wide impacts to this law. So Senate Bill 264 is going to be codified into Florida statutes. There's new Florida statute provisions that are going to be created by this law. And I'm happy to provide my notes later if you want to have these things written down. But if you want to take note of it, it will be in section 692.201 through 692.205 of Florida statutes. Those are new Florida statutes that are being created by this Senate bill. So as of July 1st of this year, those new Florida statutes are being created by this new bill that has been passed. So first, the new statute 692.202 restricts ownership of agricultural land by these foreign principals. So what is a foreign principal? A foreign principal is defined as those specific countries that I've described, China, Russia, Iran, Korea, Cuba, Venezuela, Syria. Those countries, the government of any of those countries, a political party or member of any political party from any of those countries, any partnership, corporation, organization, or any person that's a member of those from those countries, or any person that is domiciled in any of those countries that is not a citizen or a lawful permanent resident of the United States. So if you have a visa that is like a temporary visa, a student visa, there's the H-1B visa, the visas that allow you to be here temporarily. The H-1B visa is a visa that allows you to work here temporarily. That does not qualify you as a citizen or a permanent resident. Then you are still considered to be domiciled in those countries of concern. So if you're here on a student visa, if you're here on an H-1B visa, so the student visa is the F-1 visa. If you're here on any of those visas, you are not considered to be a permanent resident of the United States. So then you're considered to be domiciled in those countries. Then you fall underneath the definition of a foreign principal. And then you would fall under this new law. So that prevents you under this section 692.202, which is being created, from purchasing any agricultural land. So what is agricultural land? The statute refers back to another section describing what agricultural land is. I think we all kind of know what agricultural land is, but agricultural land is defined under another section of Florida statute. It's basically land that is used for an agricultural purpose, such as fertilizing, tilling, mowing, reforesting, the kind of things that you would expect. Nobody from any of those countries is allowed to purchase agricultural land. The statute does understand that those foreign principals may already own agricultural land. So there is a provision in the statute that accounts for that, and it requires that those people that already own that land must register. And if they don't register, then they are subject to fines of up to $1,000 a day for failing to register their ownership of those properties. The statute also provides if you're a foreign principal and you inherit property, you have 3 years to sell it. So failing to register, as I mentioned, it's a civil penalty. It's not a criminal offense, but a civil penalty of $1,000 a day for failure to register with the Florida Department of Agriculture. And the Florida Department of Agriculture can lien the property if you fail to register, and then they can have a lien on the property for the fines that they are allowed to recover for the $1,000 a day. Also, at the time of purchase, a buyer of agricultural land must provide an affidavit under penalty of perjury that they're not a foreign principal under the mandates of the statute. The failure to comply does not affect the title or insurability. So they can also record a lis pendens. There's a lot of additional things that can go wrong if this statute is not complied with. That one is probably not as concerning to you guys as some of the other statutes that come into play. The restriction, another part of it, this is 692.203. This is a restriction on ownership of real property near a military installation or critical infrastructure facility. Okay, what is a military installation? I think we all just intuitively know what that means, but it is defined in the statute as a base, camp, post, station, yard, or center encompassing at least 10 contiguous acres that is under the jurisdiction of the Department of Defense or its affiliates. The state of Florida has more than a dozen military installations. Many of them are within 5 miles of our city centers like Orlando, Tampa, Jacksonville, Pensacola, Panama City, Key West. So Florida is very robust with their military installations. This new statute prohibits the purchase of real property around military installations by foreign principals. Foreign principals, as I've just described, all of those countries. Any person, partnership, corporation, they are prohibited from purchasing property within 10 miles of a military installation. The one thing that I didn't mention under the agricultural prohibition, it's the same under the military prohibition. There is a minor carve out under which you can own what they call a de minimis interest. The de minimis interest is specifically defined as if you own a stock, basically, that owns a publicly traded stock in which you own less than 5% that owns part of something. So basically, like say you're in a mutual funds and the mutual funds own part of land, in part of a mutual fund, that is considered a de minimis interest. So that does not violate the statute. But generally speaking, the foreign principal can also not purchase any real property near a military installation. The other category is the critical infrastructure facility. That is not well defined in the statute, but generally speaking, critical infrastructure facility is some things such as chemical manufacturing facilities, refineries, electrical power plants, water treatment facilities, telecommunications facilities, gas processing plants, seaports, airports, spaceports. All of those things would be classified under this new statute as a critical infrastructure facility. So under this new section 692.203, these defined foreign principals are prohibited from purchasing property within 10 miles of any critical infrastructure facility. Similar exceptions, like I said, regarding de minimis interests. And there's similar provisions in this section. If you already own it, you must register it. Under this particular subsection, you would register that property with the Florida Department of Economic Opportunity as opposed to the Florida Department of Agriculture. This section also provides for civil and criminal penalties if you fail to register that property. Similar provisions in this section. If you were to inherit the property, you also have a limited time period under which you must sell that property. So the one that I believe is most concerning to you all as real estate agents is section 692.04, which is the most restrictive part of this new law. And that is the restriction on ownership of real property by the People's Republic of China. So this provision is the most restrictive on the Chinese citizens. And this provision prohibits the purchase or acquisition of real property by the People's Republic of China. And this provision prevents the citizens of China from acquiring or purchasing any property except for the de minimis indirect interest that I've already described from any property, including any residential properties in the state of Florida, except they are allowed to purchase one residential real property that is up to 2 acres in size only if that property is not within 5 miles, not 10, only 5 miles of any military installation. And if that person has a current verified U.S. visa authorizing them to be legally present within the state. And if that person is the person that their name is the person that is buying the property, that is the only way that a Chinese citizen can purchase property in the state of Florida. Now, so that means they would have to have, for example, the H-1B visa that I mentioned, or an F-1 student visa. So these are people, now obviously if someone is a naturalized citizen, this does not apply to them at all. We are talking about individuals who are not citizens. They are not permanent residents of the United States. These are people that are here on H-1B visas or F-1 student visas. So they're legally in the United States, but they are not citizens and they are not permanent residents of the United States. Then they can purchase one residential property that is 2 acres or less in size, cannot be within 5 miles of a military installation. It cannot be within 10 miles of a critical infrastructure. And they have to be verified to have a valid visa. And it has to be their name on the title. Similar provisions in this part of the statute that if they already owned the property, they must register the property. And then if they inherit the property, they also, and it falls within those geographical areas within 5 miles of the military installation, and they have 3 years to sell the property. Now, concerning for real estate agents and sellers is that if a real estate agent or a seller is involved in a transaction that violates the statute, then it is a misdemeanor. And if you're convicted, so prosecuted and convicted of violating the statute, you could face a fine of up to $15,000. for violating the statute. So as I mentioned in the beginning, this is obviously a very, very new statute, and there were expected to be constitutional challenges, and that has already happened. So as of Monday, the first lawsuit has been filed. The first lawsuit was filed up in the Northern District. A federal lawsuit was filed. There are 5 named defendants in the first lawsuit challenging the constitutionality of this statute. I've read the lawsuit. It's very well written. There are 4 named individual defendants and 1 real estate agency that was named as plaintiffs in the lawsuit. All 4 of the individual plaintiffs are non-citizen, non-permanent residents. All 4 of them have lived within the state of Florida for at least 4 years. All 4 of them are professionals. All 4 of them are validly in the state of Florida. One of them is here or 2 of them are here under the H-1B visas, meaning that they are here under a specialty occupation. One of them is a registered dietitian with a master's degree. One of them is a professor at a university. Another one of the plaintiffs is here on a student visa. She's getting her PhD. And then the 4th of the individual plaintiffs is a political asylee who has gotten temporary asylum and is applying for permanent political asylum here. They're, again, as I mentioned, they've all been here for 4 years or longer. 2 of them have contracts to purchase properties in the state of Florida. Both of those contracts are set to close after July 1st, 2023. Both of those people stand to lose substantial deposit monies if they are unable to close on those purchases. And both of those properties are within 10 miles of critical infrastructures or 5 miles of military installations. So both of those plaintiffs believe that they are not going to be able to purchase their homes and are looking to lose $25,000 to $35,000 on their deposits. The other 2 individual plaintiffs own houses already that are within those geographical parameters that are going to require them to register their homes. So the argument in the complaint is that it's burdensome, discriminatory, and stigmatizing to them because they're going to have to register those properties. And then the 5th plaintiff, as I mentioned, is a real estate agency that caters to the Chinese American population. And they argue that they're going to be losing at least 1/3 of their business because of their clientele. So it's going to be, economically devastating to them to not be able to cater to their desired clientele. The arguments in the complaint is seeking declaratory relief, meaning they're asking the court to declare that this new law is unconstitutional. Because it's discriminatory based upon, the ethnic class of the race of these individuals. They're also making an argument, which honestly, based on my initial analysis of what they're arguing, I think is probably the best argument. They make a very good argument that the federal government has the exclusive right to determine whether there's an interest in let me back up a little. Constitutionally, the only way for a law to be discriminatory is if there is a compelling interest that overrides an individual's right to be free from discrimination based upon race or ethnic background. And the argument is that only the federal government has that compelling interest, that a state government doesn't have that compelling interest, and that the federal government has passed various protections, and that this is a federal question and not a state question, so that the state doesn't have the right to implement such a law, that it would be for the federal government to institute such a law, not the state government to institute such a law. So that's a very high level analysis of what they're arguing. But I think that it's possible, very decently possible, that at a minimum, there will be a temporary injunction in place about this law while this lawsuit and potentially others kind of make their way through the system. But as of right now, this law is going to go into effect as of July 1st unless the court intervenes and potentially stays implementation of the law until the lawsuits make their way through the system while the courts determine whether it's constitutional or not. So I'm sure you have questions. There's a lot there, but the bottom line is you have to be very, very careful about these transactions with foreign principals, and in particular with the citizens of China. So let me hear your questions.
All right, Juliana has a hand up. And Romina. Juliana, are you ready? There she
Yes. So you mentioned that they need to have a permanent permission to stay here. And you mentioned Venezuela. A lot of them are under asylum. Does that qualify as permanent?
Then that should qualify for them, but it depends. You know, if they're here under permanent asylum, then they should be fine. But if it's a temporary asylum, then I would be very careful about that.
Right, because many of them are still in the process. They haven't gotten the asylum approved. So,
Right.
Okay.
Yeah. So I think if they've officially here on permanent asylum, I think that the analysis is different. If it's a temporary asylum, then they're in danger, of course, of that not being permanently approved, and they could have a difficult problem in the future because then they own a property that they can't own.
Right, it falls into that. Okay, perfect. Thank you.
That answers the question we had in chat as well. Thank you, Juliana. If you put your hand down, please, that'd be great. Next up is Romina.
Yes, I would like to know, how can we know if somebody for those countries, let's say they have an LLC to purchase a property, how can we actually know if they're from China, Venezuela, or any of those countries if they're buying under a company?
If they're buying under an LLC, you're going to have to look into the LLC, and you need to know who the principals of the LLC are, their members, because the statute is very clear that it's, you know, a partnership or association, organization, corporation, or any other combination of, you know, persons. So if they're buying it in an LLC and the members of the LLC are not residents, you know, permanent residents of the United States, if the members of the LLC are foreign principals as defined by the statute, then they're going to fall under the statute. So you would have to know if they're from those countries, the foreign countries of concern that are defined in the statute, those 7 countries that I've identified.
Yeah, the thing is that, for example, it's a little bit hard for us as a real estate agents to, let's say, go to Sunbiz, find out who's the members of the companies are, which I know they're going to start next year. They have to show every single member of the company. But honestly, how can we know if these people is an illegal, let's say, if they're permanent residents or they're citizens, or if they could tell us whatever they want, but we don't have the ways to find out if they actually legal or not. So how can we find out if they're legal in this country or not? We don't know.
Right.
Because
And right. No, I understand. And that's a valid concern. And part of the process is going to have to be that when in the closing, during the transaction, they're going to have to do an affidavit. That's part of the new law, is that an affidavit is required. And so obviously this is brand new. And so title companies are going to have to work through what this is going to look like as it goes into effect. And I'm envisioning, because the law specifically is requiring that an affidavit is required from purchasers of these, properties that fall within the parameters of this statute. I'm imagining that just like, there's affidavits now that are required in a closing, they're probably going to require affidavits from the members of an LLC. If an LLC or a corporation is purchasing a property or a partnership, they're going to be requiring affidavits from all of the members under penalty of perjury, attesting that these buyers are not foreign principals. So, as a realtor that's involved in the transaction, in order to avoid potential criminal liability on your own part, you do the best due diligence that you can. But ultimately, at the time of a closing, a title company is going to be requiring the affidavit that the statute says that requires this affidavit from all of the principals of any company that's purchasing a property, whether that company be a limited liability company or whether it be a corporation or if it's a partnership. They're going to have to get that affidavit from all of the principals in order testing. And if they lie in the affidavit, that's not going to be on you, but they're going to have to get those affidavits from all of the principals attesting that they're not foreign principals under the statute's definition.
Okay, and thank you. And the other thing based on that, let's say we have, and I'm asking all this because I do work with a lot of foreign people.
Yes.
So let's say we have clients that are looking into to purchase a property. Where or how can we exactly know what are the limits or what are the locations where they're not gonna be able to purchase? So let's say if we put a map, how do I know myself this is a place I can buy, this is not a place I can buy, this is a place? How it's gonna be? I don't know how to
right. I think that the implementation and the enforcement of this law is something that we're all gonna kind of have to feel it out as we go along, because you're right. How do you know if it's within 5 miles of an airport or 10 miles of a military installation or vice versa? I mean, though I think this is what the law says. They oftentimes will implement or pass a law and they're not quite sure how we're going to work through it and figure out how to know those things. I don't know the answer to that question. Is it as the bird flies or as the car drives? That is not defined. And sometimes, to be frank, sometimes those types of things are not fleshed out until there's a violation, and then a court comes in and interprets the law and says, well, 10 miles means 10 miles as the bird flies, or it means 10 miles as the car drives. And then we kind of, work through that. I would say that you should err on the most conservative side. So if you were to say, okay, I'm looking, my Chinese client is looking to buy this property, and I'm going to map it out, and I would map it out in every different possible way and make sure that it's as far away as possible just to be safe, because at the end of the day, it's your liability that you need to worry about. And I understand that this is devastating for some of you, particularly those of you that regularly deal with foreign clients, and you want to protect your business, but you also need to protect your license and your reputation and your pocketbook at the end of the day, right? You don't want to get a misdemeanor conviction, nor do you certainly ever want to pay, a $15,000 fine. And so you need to try to figure it out the best way that you can. But we're all going to be like a little bit shooting in the dark until this thing gets figured out. I did see a question there about, can we get a list of critical installations and military installations and critical infrastructures? I don't know that we can. I mean, certainly the military installations, we ought to be able to get a list of those. That's easy enough to do. As far as critical infrastructure, I think that's going to be a lot more difficult because I think they're everywhere. I mean, honestly, I think it's that when, especially once you start talking about things like refined water treatment facilities. I mean, for goodness sake, the water treatment facilities are everywhere, right? Almost every community has a water treatment facility somewhere close by. You know, I think I've lived in 5 different houses that have had water treatment facilities a stone's throw away, because most major metropolitan areas have water treatment facilities nearby. And so that's going to be a tough one. Airports too. You know, there's obviously there's international airports, but there's commuter airports, and they're all scattered around. I mean, the entire state of Florida. I mean, Florida, we all know it's a long, skinny state, and so it's kind of hard to go anywhere in the state of Florida. I mean, I read a couple of commentaries about the new legislation that said, obviously, the outer parts of the state on both coasts are going to be pretty severely impacted. The real estate on the coast, all the way up and down on the east and the west coast, are going to be pretty severely impacted by this. The middle corridor, maybe not quite as badly, but anything around the bigger cities like Orlando still is going to have an issue. If you're in like Highlands, maybe not so bad, but I mean, I don't know that you guys are selling property there. It's the areas where you guys are selling properties to international customers or clients are going to be the areas that are probably most impacted. Any other questions?
Yes, there's quite a few. Daniel.
I'm sure.
You're on mute, Daniel.
Here we go. Okay. Yeah, she answered one of the questions about the title company would investigate. How about the lenders? Can we count on the lenders to give us a hand and maybe find out about these visas and all that?
You mean certainly
Would they
they
investigate?
they might, but I think that there's nothing that I saw in the statute that imposes any liability upon a lender. I mean, the liability that that's there is upon the person, the individual who's involved in the transaction, and it specifically references sellers and realtors who are involved in the transaction. So ultimately, the burden is going to be on you to not be involved in a transaction that could violate this statute. So as unfortunate as it is, you're going to need to be as diligent as you possibly can be to avoid potential liability. I wouldn't rely upon a lender. I think that the title companies are probably going to do some diligence as they normally do. That's not to say that they're not infallible, because I think we've all seen that title companies make mistakes. They are supposed to verify identity, and they don't always. They're supposed to get affidavits, and sometimes they make mistakes, but ultimately I would not rely upon a lender to do proper due diligence. And the other thing too is, I think a lot of times these foreign investors, sometimes these are just individuals, like the 4 plaintiffs that I described in this lawsuit. They're probably just regular people like you and me that are living here and working, a professor, a dietitian, someone getting their PhD. They're just, a regular, person just getting a loan and buying a house. So that may be normal, but some of the bigger investors that are coming and buying property, a lot of times those people are cash buyers, and so a lender would never come into play anyway. So, I think the best advice I can give on this is that you need to just be really cautious, and hopefully find out the most that you can. And I know that it's going to scare a lot of you off from representing customers or clients that fall into these categories, that are these foreign that are from these foreign countries of concern that are identified, unless this law is struck down.
Kathy, I have a question for you.
Yeah.
What about taking our regular buyer brokerage agreement and putting a sentence, maybe something that you could even write for us, in the additional term saying, buyer attests that he or she does not apply to this, whatever kind of wording we would use, that this did not apply to them. And then and that kind of removes us. They give realtors the burden here, but we have literally the least amount of tools to check on these things. We have no way.
Yeah.
So what we have to prove is that they lied to us. That resolves us, right? Because they're signing affidavits and stuff like that at closing. They can lie to title companies. They can lie to whomever. But they, if we write something, just a one sentence, one paragraph in the additional terms that says that they attest that this does not apply to them, and put it in our buyer brokerage agreement, and maybe our realtors will actually use the buyer brokerage agreement, and they'll sign it, and it will protect them.
Well, I think it's certainly not going to hurt. And so what we would do if we wrote something like that, they would attest to their status as not being, a foreign principal under the statute. And then what I would include, if we were going to do this, is I would include an indemnification clause. So that means that in the event that it's found that they lied to you, then they would have a duty to indemnify the FRI as the broker and the individual agent, whomever that may be, for any potential, civil and or criminal penalty that may arise. So if, for example, Daniel was subjected to a $15,000 fine as a result of some malfeasance that was found by a government agency because he, inadvertently represented a foreign principal that lied to him, then that foreign principal would be required to pay that $15,000 fine, which would at least relieve him of the fiscal burden of that. But that still doesn't mean that he would be off the hook of a criminal, judgment, so to speak. So meaning that if a court found him criminally responsible and he got a misdemeanor conviction, I can't promise that a clause like that would relieve him of that criminal conviction. He still may have it. It just would mean that he could go back to whomever that client or customer was and say, you have to pay the $15,000 for me because of that indemnification clause. So going back to what I said, is the point is, it's not going to hurt, but it might not be a complete cure-all, because you may not be able to completely absolve yourself of criminal liability because of it.
Okay.
It's
Thank you.
better than nothing,
Thank
and
you.
certainly I can write that up for sure.
All right. Clarence. Clarence.
Yeah, sorry, I'm here.
No problem.
Yeah, so a few questions. Some of what's kind of been covered already, but it would seem to me that in order for us to determine places that are not eligible or eligible, that there be some type of mapping system created, similar to what is already available for to identify opportunity zones, things such as that. But anyway, so, as Romana and some others had alluded to, it's going to be very hard for us to try to determine where we can and where we can't. But along those lines, some of the major issues, like with the critical infrastructure, is power line grids. Some of these are heavy grid areas, also solar panel of solar farms. So it's just going to create a whole slew of issues for us. In addition to that, the military installations. It's pretty obvious for the major installations, such as MacDill and Patrick Air Force Base and so on. But there's a lot of other smaller locations, such as Guard and Reserve installations, or centers or posts or armories, whatever you want to call them. Some of those may reach to 10 acres, some may not, but those are still military installations, and they're sprinkled all throughout the state.
Yep.
And as far as finding a list of where all those installations are at, I have those. So
Okay.
if anybody on the call is interested, I can share that. But also recruiting offices, military recruiting offices, they are also sprinkled even further, across the given area. And then the last issue is in regards to agricultural land. So depending on the actual zoning, agricultural land can be used for a variety of things outside of agriculture, such as residential, such as commercial, and so on. So if we have one of these foreign principals looking to buy agricultural land and use it for something else, is that still an issue, or is it just strictly tied to agricultural?
Yeah. Okay. So a couple thoughts on everything you just mentioned. Number one, I wouldn't be at all surprised if there aren't people trying to capitalize on this statute and who start producing some kind of, mapping or app or something, assuming that the bill goes into effect and is not otherwise, stayed or declared to be unconstitutional. There are always entrepreneurs out there capitalizing on everything. So although that is outside of my wheelhouse, there are people that are way smarter than me on the sorts of things that you've just identified who could come up with an app or come up with a mapping device or come up with something that sets forth all of the critical infrastructure facilities, all of the military installations, and develops, and maybe one of you guys is this person, and I just gave you an idea, to create some kind of app where you can go in and put in an address and it will immediately populate all the things right around it and tell you how far away they are. So I'm sure that some smart person is going to come up with that will be helpful to help you figure that kind of stuff out. As far as the agricultural thing, the agricultural land issue in this new statute, it specifically refers you back to a very well-established statute, which is section 193.461. And that is what defines whether land is agricultural land or not. And there are lots of different factors within that statute to determine whether a land is agricultural land. And you actually have to get land declared, or I don't know if rated is the right word, but as agricultural land. So it has to be used primarily for bona fide agricultural purposes. So if a foreign principal purchases land that is agricultural land and then tries to use it, well, first of all, they can't do it. So any one of those 7 categories, 7 countries of foreign concern, citizens of those 7 countries of foreign concern cannot buy agricultural land, period. So if it's already declared to be agricultural land, they cannot buy it. So if they wanted to buy it and then convert it into something else, they couldn't buy it in the first place. So so if they bought land that's not agricultural land and then they wanted to try to get it declared to be agricultural land, that would be a completely different process. And I doubt that they would be able to get it declared agricultural land. So so I don't see that actually happening. I think that they would never get it approved as agricultural land if it wasn't already. And if it is already, then they can't buy it under the new statute. So but there's certain factors under that section 193.461 that talk about whether land is agricultural land. And it normally agricultural land has been used as agricultural for quite some time.
Okay, Ida.
Yes, Catherine, first of all, thank you for this information. Oh my God, this is like a handful, amazing. And I know that you're gonna be hiring a lot of people because this is a hot topic. My head is exploding, and boy, are we not gonna be losing a lot of business in the state. Is crazy. And I wanted to piggyback on something that Romina mentioned. Will it be smart if we ask those foreign buyers that we know are from either of these countries, for them to provide a passport or the identification that shows maybe they are already a legal resident. And so we will not waste our time, their time, prior to a purchase, a transaction going to closing, where the title company had to verify this information as well. What do you think of that if we ask for something like that? And when we ask, we can, I don't know if you agree that we can maybe perhaps add that this is a process in place by our brokerage. So we don't feel bad asking as well.
So, Carissa and I talked about this identification issue, I don't know, 6 weeks or 2 months ago, in the context of something completely different. And it wasn't related to this new statute, but just in relation to the proliferation of fraud that's been going on. And I believe that it's important for you all to be verifying identification in any event, to the extent possible, in whatever form you need to be doing that, because there has been an increased incident in the in fraud in real estate transactions, which I'm sure you're all aware of anyway, and in particular with foreign buyers and sellers and transactions, where there's been a lot of instances recently. I've become aware of several in which properties are owned by foreign people or companies, and they're being sold. And I did the air quotes because the seller actually has no idea about this transaction, and they're being listed by someone who's not actually the seller, and people don't know that their property is being sold by someone who's posing as the seller. So we've talked about the importance of trying to verify identity in whatever form you can. So I think that it's important for you to verify identity, whether it's by passport or any other form of identification, but certainly passport would give you a sense of whether they're citizens or not, or permanent residents or anything else. I don't know if that makes you all uncomfortable, but given the fact that Florida, it's not your fault, it's not FRI's fault, but there is a law in the state of Florida right now that requires you to verify whether they're a permanent resident or citizen of the United States in order to complete the transaction. And so I think you have to, because you have to protect yourself. You have to protect your criminal liability, and you have to protect the criminal liability of your brokerage. So I think you have to do it.
Thank you.
Like it or not, I think you have to.
I know we pretty soon will have to be required to have a law degree as well.
Well, even that, and as I said a few minutes ago, sometimes they pass these laws and then there's a lot of interpretation that's going to have to happen if the law even stays. We went through this recently. This is like a completely separate topic, but on the property management side, we went through this with a new ordinance that came into place in Orange County, that laws get passed and they don't make sense, and there's a lot of permutations, and so a lot of times these things get fleshed out over time, and we have to kind of see how they play out once they actually come into effect and they're implemented. And then the issues arise, and then the court system actually has to start interpreting the law when those things happen. So I know there's been some comments too, and it's hard for me. I can't really read them when I'm talking, but if there's something there, and maybe someone can let me know if there's questions that are popping up in the bar down there. And I don't know if Ryan's talking to me, but he's muted.
Sorry about that. I've been having coughing fits. Sonia,
Oh.
are you ready?
Yes, I'm here.
Okay.
Well, yeah. Thank you, Catherine Smith, and thank you, Ryan. Thank you, Carissa. Actually, Ryan already gave one of my points, and Aida gave the second one. But I still have a question from the Aida's point. You know, is it lawful if I ask for their citizen status? Like before, it was like I really don't know if it was unlawful to ask, but that is still my question. Is it lawful to ask for? And my second question is, what is the name of this law? Is it 1718 or 1718 is a different one?
So, so I see the question down there too about, are you going to get in trouble under fair housing laws for asking for this, for your citizenship, their citizenship status? And, you know, it's a valid concern, but you know, you have potential criminal liability if you don't verify. So I don't think you have a choice at this point. And so I don't think you're not going to have a problem. Unless, I mean, if a law is declared unconstitutional, then, you know, then you go back to doing things the way that you were doing them. The law, I think it does have a name. As it was Senate Bill 264, and as I mentioned, it's being codified. Codified means put into a statute in those sections that I referenced, which is Florida statutes, sections. I've scattered on my notes. 692.201 to 205. But I believe that there's going to be a nickname for the statute. And the nickname is going to be, I think it's something it's called Florida's new, it's called the Alien Land Law, is what the Alien Land Law is what they're going to be calling the law.
And Catherine, since I have it right here with the new law, also 1718, the one for the immigrants, what are your thoughts? Let's say for a rental property, somebody show me an ID, driver license, and they identify themselves with a driver license. However, you know, I know a couple of people who have driver license and they're not legal here. And let's say that the person, it's legal, but the wife is not. How will we manage that if we have a tenant right now and the law is going to start soon? How, like, you know, because they say you cannot protect or you cannot have anyone that doesn't have a legal citizen status. I think that's what the law says, 1718, that you can, you know, restricting immigrants. So if they see you with not see you with an immigrant, but if you have an immigrant in your car or in your house, you are liable as well, or you're committing or against the law, or maybe I'm interpreting that law.
Yeah, I think, yeah, that's the immigrant law. 1718 is something different. 1718 and how it interacts with this one. That's an undocumented immigrant law is what you're talking about.
Correct.
And so what you want to know is how that interacts with this law?
No. I would like to know if there's, well, right now we're talking about this law. Can we have a second session in regards to this law so we can have, you know, certain questions? Like I say, even if it's a rental property and one is legal, but they have somebody else like wife or somebody else or a kid that is not with a legal status, how will we be affected as agents?
I'm happy to take a look at that and try to answer questions about that law on a different day.
Okay, thank you so much.
Sure.
Just to clarify, it has never been illegal to ask about citizenship. You have to ask your sellers about that for FERPTA.
Yeah.
So it's citizenship. It's not a protected class. So asking if someone's a U.S. citizen has never been protected. Next.
No, it's I think it's the ethnicity that they're concerned about, or the race is the issue
Right,
that
sure.
they're concerned
It's
about.
the way that you ask it, right? I mean, if you ask if someone's a permanent resident or a citizen, then right, that's not particularly protected. But if you only ask certain people and you only ask certain people maybe who look Venezuelan, then maybe we do run into an ethnicity problem.
That's
Right.
why I like it as part of our paperwork and say it's everybody signs it, whatever they look like, right?
Right. And obviously if you've got a law that requires that people be permanent residents or citizens of the United States, and then you've got 7 countries that aren't allowed to buy land, then you have no choice but to verify that they're not foreign principles under this new law. You don't have a choice. You have to.
Right. Javier, you're next. You're still muted. Romina, can you translate? In the room.
I can't.
Romina's in the same room, so I don't know if she can tell.
Yeah.
You're muted, Javier.
Javier, I can't hear him.
It's the little thing at the bottom. Oh, you're still muted, even though you shouldn't be.
Javier, tu micrófono está apagado. Abajo a la izquierda. Se ve como un micrófono, está en rojo, ponlo en gris.
Even when he's not muted, though, you can't hear him.
Ya.
I'm unmuting mine, so do it.
Hello.
Mutea el tuyo y habla del mío.
Can you hear me now?
Yes.
Yes.
There we go. Okay. Thank you, Cindy. Okay. The thing is this. Let's say actually we have a client, Romina and me, that one of the buyer is a legal resident, right? And but the income she has is not enough to buy the house they want. So she needs the income of the mom and the sister. But the mom and the sister are in the process of asylum, not even approved in the process. But that person that has a legal status is purchasing the house, but she needs to add the mom and the sister. Is that legal? I mean, could be because that person is legal. Can she add the income of the other person or not?
That's going to become a lender question. I think that under the new law, I would, and are they from one of the countries?
Venezuelan?
Venezuela.
Yeah, they're Venezuelan. Yeah,
Yeah. So I would say, well, what are they buying?
they're buying a house.
But in Kissimmee, the thing is that now we don't know if it's going to be close to those restricted areas. So the thing is, what happens if you already have somebody, let's say under contract, and it falls into that, and obviously they're going to close, let's say after July, and the case that he's telling that she's the one who has asylum, political asylum, but it's not. I think every single political asylum are temporary.
Temporary.
Yeah, they're not permanent.
So in that particular, I mean, that's a tough one. I agree. They're not it's not as strict on them as it is on someone from China. So under that particular analysis, they're only prohibited from purchasing near the military installation or the critical infrastructure facility. If it's not, I think they're probably okay, or the agricultural land. So if it's a house, they're probably okay. ideally, the one person should buy the house just to be safe. If they can't, I would work with the lender and see, because there's, sometimes there's different ways that lenders can work a deal where they can approve a loan with a gift or something like that. That's outside of my wheelhouse about what a lender might or might not be willing to do. I know that sometimes parents can loan money to kids and things like that, and do different things to make the loan work. But I would try to do some groundwork and figure out where that house is in relation to some of these, if you can figure it out, or see if you can get it closed in the month of June. I know
Yeah, it's possible.
I think in that particular one example that you've given, you guys need to do some groundwork in the next few weeks and see if you can make this one work for them under those circumstances. The temporary asylum, I don't know the answer, honestly, under the law, whether a temporary asylum may or may not work. But I don't want you to have exposure as the realtors on this deal. And if you can figure out whether there's a military installation or a critical infrastructure facility nearby, or if there's a way to structure that loan to not put those two political asylees on the deal, would be the safest thing to do under that circumstance. But you've got an unfortunate example there that's got a couple different layers of questions that are hard to answer without knowing exactly where that property lies.
Thank you.
All right, thank you.
All right. Thank you, guys. Josie.
Hi, thank you so much for this session. It's very helpful. I just logged in like 11. I missed like a first half of the session, but it's really helpful. It's helped with a lot of my questions. And I also have questions. So I'm originally from China. So most of my clients, they are Chinese, but some of them are already US citizen, or they have a green card, but some of them, they have like a lawful immigrant or lawful like visa, but as it take a very long time for them to get green card. So they are same as us, live here for school or for work. They have kids, they just try to find a home here to close their work or for good for their children. But if like for any reason, like a seller just didn't want to take a risk to identify, is that lawful, like they qualify to buy a home or not, they just reject my offer. Like I represented Chinese, they just reject it. And then we like they didn't even check what the status, what we can do. It's like this definitely against the Fair House Act. It's not fair, but if they just didn't want to consider our offer, is there anything we can do?
Well, that's a really challenging question that you're asking, because I agree with you that it certainly appears that they're being discriminatory if they're just rejecting an offer based upon someone's name, which is what it sounds like you're describing to me. If you look at it from a buyer's side, if a buyer or the buyer's agent is advising them, you could have criminal liability if you sell your house to someone who's a foreign principal under this statute. Then you can understand why a seller may be gun shy to accept an offer from someone who's potentially a foreign principal. I think that a seller should do a little due diligence to find out or ascertain, or at least the real estate agents involved should do some before they just outright reject an offer rather than be discriminatory. But it's a hard question to answer as to what they should do. Perhaps if you are representing a buyer and you're submitting an offer on behalf of a buyer, and this is just a suggestion that I'm making, and I hadn't thought this through, so I'm just making it off the cuff. If you are representing a buyer making an offer on a property that they really want, perhaps submit an affidavit with it that attests that they are not a foreign principal.
Well, and it's very hard to say, like they might allow to buy a primary home within the like you guys talking about like military installation or critical infrastructure. It's kind of very hard to describe. Maybe they only allow to buy a house very, very far away from city. That is unfair to them, and they are on the way to get a green card, or they are just because everything takes time. They are just lawful here, and then they are not allowed to buy a house just like everybody else. And then we also afraid that the buyer might sue us because it's against the constitutional law and against the Fair House Act. They could do that. So one hand, we are afraid of that the government going to fine us or we saying that we're doing illegal transaction, and then sometimes it can be very hard to determine is that illegal or this illegal, even though that we hard to determine is that this house they allowed to buy, and it's so hard for us, like not very expert on this area, and then they put this like responsibility on realtor, on seller. It's not right. And also on the other hand, buyer could sue us because we didn't follow the rule of the Fair House Act. It's kind of very conflict to each other. Whatever we do is like not right.
Well, yeah, it's absolutely challenging. And, there's a law that's been passed. And if the law actually goes into effect on July 1st, as it's set to do as of right now, then you have an obligation to follow the law. There's nothing that you can do. I didn't write it. You didn't write it. None of us in this forum wrote it, but we all have an obligation as professionals and as citizens of the state of Florida to follow the law that's been passed. So there are professionals out there challenging the law. And while that process goes through its permutations there, we have to follow the law that's in existence. And like it or not, disagree with it all you want, we have to follow it until a court tells us otherwise, or until the legislature tells us otherwise. We're obligated to follow it. And so if you have a client that is not a permanent resident or a citizen of the United States, and they are domiciled in one of those 7 countries, then they have to only purchase properties outside of that 5 to 10 mile radius, depending upon what the issue is, whether it's a military installation or critical infrastructure facility. And that's it. That's the only thing that they're allowed to do. And it isn't fair, it isn't right, but it is the law, assuming it goes into effect on July 1st. And so, that was my only suggestion I could make, is if you do have somebody who actually is a permanent resident, with a permanent resident documentation, or someone who's become a naturalized citizen, then certainly they have every right to purchase any property anywhere in the state of Florida. And so that's why I said if they are, and maybe they appear to be, a Chinese immigrant that someone might not believe that they are, then they could submit the documentation to show that they have the right to purchase property. Otherwise, the only thing that you can do is follow the law that's been passed. And be careful to protect yourself and the brokerage.
Okay, thank you.
Sonia, you have a question.
I do. I have a very quick question. Does the law states or tell us all the critical installations?
It does not. No, the critical infrastructure facility is not super well defined in the law. I found, other places that give examples of what they are. So what it says is it's any of the following if it employs measures such as fences, barriers, and guard posts designed to exclude unauthorized persons. So some of the examples are chemical manufacturing facilities, refineries, power plants, water treatment facilities, telecommunications facilities, gas processing facilities, seaports, airports, spaceports. So that I would anticipate that if this law goes into effect over time, the definition of critical infrastructure facility will become refined by the court system as this law is challenged and interpreted. That's just how the legal system works. The legislature passes a law, and then the court system interprets the law. And so as challenges are made to, there's a case where someone tries to buy a property and someone challenges it, and because they say that it's within 10 miles of a critical infrastructure facility because a cell phone tower is a critical infrastructure facility. And then someone else says, no, that doesn't count as a critical infrastructure facility. And then they go to court, and a judge in a court determines whether a cell phone tower is a critical infrastructure facility. That's just an example. I don't think a cell phone tower counts because a cell phone tower doesn't have fences, barriers, or guard posts to keep people out. But those, a water treatment facility, I would think is a critical infrastructure facility. I mean, you have to think about the reason for the law, and someone could, if someone was trying to cause harm to the citizens of the state of Florida or the citizens of the United States, they could introduce some chemical warfare into a water treatment facility that would harm the citizens of our state or our country. So that's why they would try to keep these foreign principles away from a water treatment facility. So if you think about the reason for the law, whether you believe it to be ill-advised or not, if you think about the rationale for the law, then you can kind of understand what a critical infrastructure facility is and why they are trying to keep what they call foreign principles away from living too close to those facilities where they could infiltrate those facilities to do harm to the citizens of our country.
I understand. Thank you so much, Catherine. However, I do have another comment. In my understanding, for everything that you're saying, and it's been said over here, is that honestly, I don't feel like working with any type of that kind of people because the liability, it's too much because of the uncertainty of the law that it's already in place or it's going to be in place soon. I'm at this point, I'm sorry, I didn't get if it's already in place or not. And if it's not clarified, then, it's like, okay, I did this and I'm still, if it was unlawful, I'm still, I'm going against the law and I'm going to have consequences, right? Because they say, the law says, even if you didn't know, it doesn't mean, kind of, I don't know if I'm understanding that. So based on that, I'm like afraid to work with certain type of people because of that. Like, I don't want to get the risk, later on they say, hey, they purchased the house right here and the law was in place. It's scary. I don't know.
It is frightening. I mean, I certainly understand how you feel because the law is imposing upon sellers and on realtors a duty to make sure that you're not violating the law. So you have an obligation. I mean, you're doing the best that you can at this point to try to learn about the law and do the best that you can to follow it. But it does impose upon you a duty to do the right thing and follow the law.
I have a question. If somebody, I don't know. Is somebody before me?
Yes, Ida was next.
Okay.
Well, she took her hand down. Go ahead, Ramina.
Yes, so
Okay, sorry.
I know you said before that if somebody inherited a property, they have to sell it within 3 years. Also, obviously, they cannot purchase, where we've been talking. Now, my question is, what if somebody already closed in a property within the last year, maybe 2 years? That part I missed. What do they need to do to be legal under, I don't know, the law or something? So
Right.
let's say somebody already closed on a property close to those areas.
Yeah, so if someone already owns a property, it depends upon what classification of property it is. So they don't have to sell it. So if they bought it, if it's an agricultural property and they already own it and they fall within the classification of the foreign principal, as I've defined foreign principal, and they own an agricultural land, then they have to register that property with the Department of Agriculture and Consumer Services, which is called the Department of Agriculture. If they fail to register the property, and they have to register the property, I think it's by the beginning of the year. But they have to register the property. If they don't register the property, then they're subjected to $1,000 per day fine for every day that the registration is late. They have to get that property registered. And then if they don't, and then the fine then would, if they don't pay the fine, then the fine will become a lien on the property. Okay, so then if they own the other types of properties, so say they just own a residential property that happens to be too close to a military installation or a critical infrastructure facility. They own a house and it turns out that it's within 5 miles of an airport. They already own it. They don't have to sell it. They have to register. So only the agricultural properties get registered with the Department of Agriculture. The other properties get registered with the Department of Economic Development. The Department of Economic Opportunity. They have to register those properties. And if they don't register those properties, then they also would be fined $1,000 a day for failing to register the properties. And the same kind of measures are in effect penalties. They'll get penalized with a fine, and then those fines can become a lien on the property. Theoretically, the property could be seized for failure to pay the liens. There could be a lis pendens on the property, and all kinds of, horrific things can happen if they don't. So basically, if you have an owner that you know of who owns a Chinese or Venezuelan or, Cuban American citizen that owns a property, they need to get them registered. If they don't register them, then they're going to get fined.
Okay, so none of the cases, they have to sell it. None of the cases. In none of the cases, they will have to sell.
Just the ones who, if someone inherits a property after the law goes into effect, then they have to sell it. Because they understand, sometimes that happens, that someone who's, maybe someone who lives here, who's a citizen, but they die and their heirs live in China, then those people cannot own it. They'd have to sell it. But someone who already owns a property, then they're not going to make them sell it. They just have to register.
Thank you.
Okay, guys, we have time for 2 more quick questions. I hope, Kathy. Let's do.
Yeah, sure, no problem.
Okay, Ida.
Yes, Catherine, based on your experience, when are we expect to hear if the class action lawsuit against this law that should come into effect on the 1st of July will be like a stop? When would that take effect? I mean, for this lawsuit, what is the time frame on that based on your experience?
So generally speaking, the governmental entities, this lawsuit was filed against members of the government. It was filed against the Florida Commissioner of Agriculture, the Florida Secretary of Economic Opportunity, and the chair of the Florida Real Estate Commission. Governmental entities like that normally have 60 days to answer a lawsuit. And instead of 20, which is the typical, they have, I'm looking to see if they asked for,
Extension.
if they asked for a, emergency injunction, and I don't see that they did. Obviously, this was just filed on May 22nd, which was Monday. I don't know, and they're asking for, the court to declare the law to be unconstitutional. They did ask for a preliminary injunction, so it's possible that the court will grant what's called a preliminary injunction, which would halt or stay the enforcement of the law until such time as the defendants, being those department chairs that I just mentioned, have an opportunity to respond, because normally it will take them longer to respond than they have to before this law goes into effect. And then it will be fully briefed and argued, and it'll get appealed, and it's going to go up the chain of command. So I think that this one is going to take a little while for it to go through the process. But if you remember, several years ago when we were dealing with a lot of those, there were lots and lots of lawsuits that were challenging the various rent, the COVID rent restrictions, and the things that were in place preventing evictions, the eviction moratoriums and stuff. And there were lots and lots and lots of lawsuits, and they took forever. And then they would stay things, and then stays would get overturned, and they would put another stay in place and stuff. So I think there's a possibility that this law, the implementation of this law might get stayed before July 1st. But my best advice is that you all assume that this law is going to go into effect on July 1st.
Okay.
I would also expect that there will be more lawsuits besides this one. I think others will get filed. And this one was filed on behalf of the of Chinese people only. I think that there will probably be others filed. I think that the restrictions against Chinese citizens buying are the most restrictive, and that's why they started with them. I think there will be more. They may all get hurt at the same time, they may not, but it's going to take a while to work its way through the system. So
I have a comment for somebody asked something. The anxiety that this law is creating to those that seeking to work with and are working with foreign citizens from these mentioned countries. You know what? There's nothing that we can do but let the process follow through. And when in doubt, then we call our brokers, right? Our sales manager and Catherine, right? Because Catherine is going to provide her number, and she's going to be hiring more people because there's going to be a lot of calls, right? And so there's nothing that we can do but just take a deep breath, do our due diligence, and move on, right? Just be careful.
Perfect. Yes, Catherine, please put your number in the chat for everyone, if you don't mind, however you prefer to be reached. And we have one more question, and that is from Winnie. Winnie, are you ready? She's unmuted herself, but I can't hear her. Winnie, we can't hear you. If you want to put it in the chat, you can. We do have one question in chat. Should FREC be responsible to identify the rules and requirements for agents to follow?
I would expect that FREC would put out some kind of guidelines, but I don't know if they have an obligation to.
Okay.
you know, I would, just like I said about, you know, I think that a lot of people and organizations are going to probably capitalize on this. I would anticipate that they would probably put out some guidelines, you know, because they're your governing body. So I would think that they probably would, but they may, they're probably kind of scrambling right now too, trying to figure out how they're gonna handle this.
All right. Krista says we'll see guidelines from realtor associations here pretty soon. She thinks.
Yeah, I think so. I do.
Winnie, are you there now? No. Okay. Winnie, you can put it in chat. And Catherine, we really want to thank you for your time. Catherine's information is in the chat. Yes, she'll be happy to help you guys with what you need, you and your clients. Thank you so much, Kathy. I really appreciate you coming in. I think we all learned a whole lot.
Yeah, if there's, you know, if there's any substantial development, if I find out that the law has been stayed, or, you know, if there's been any further lawsuits filed, or, you know, any big development in the court system based upon the litigation that's coming out surrounding this, I'll certainly, you know, can write something up and pass it along to Carissa and Ryan, and then they can send something out and let everybody know. But like I said, as of right now, I think you should all go forward, assuming that the law is going to go into effect on July 1st. So that's about 5 weeks from now. And which of course means that that's affecting transactions right now, right? Because anything that you're going to, you know, any deals that you're making now would most likely not close between now and July 1st. So so you need to be operating under the assumption that this is the law, and it's, you know, we don't have to like it. We just have to follow it.
Hey, Catherine, can you
Yes.
share your email? Because I know phone, you can get bogged down with the phone calls.
I
Can you
do get
share-
bogged down. That's a good point. I absolutely get bogged down with phone calls.
Okay.
I have a hard
So-
time answering them all.
Catherine's email will be in the chat as well.
I don't know why this is so tiny. It's hard for
Winnie,
me
I
to
can
even
hear
read
my voice.
my own writing.
Go ahead.
Is there another question?
I think Winnie may be able to talk now.
I'm going to share your name with the global group. I'm a member of it. And because, you know, we are global, right? So we all need somebody like you. And I'm going to pass on your name to probably come and speak. All right.
Awesome.
Okay.
All right, everybody. Thank you so much again, Kathy. We really appreciate you coming in. Thanks so much. You're getting lots of thanks in the chat as well. And we really appreciate you guys.
You're welcome.
Kathy's there for your real estate needs. Sorry, your law needs for your real estate.
Yeah.
And a lot of your owners' needs, HOA stuff, whatever it is that you guys need, business agreements, all kinds of stuff. So, Kathy, thank you so much.
You're
Really-
welcome. My pleasure.
All right. And guys, we'll see you. Thank you, Carissa. Thank you, everybody. We'll see you guys next week. Thanks. Bye, everybody.
Bye.